Great, thank you. So I'll speak briefly to these amendments. I foreshadowed earlier the content of what these amendments are. The First Amendment, number 1, preserves the test that's been inserted, but seeks to make sure that where bail has been granted, because the judicial officer has a high degree of confidence that the young person will not commit a serious indictable offence while on jail, that bail be subject to 2 conditions: the imposition of a curfew from 8 to 6 p.m, and then electronic monitoring to ensure that that curfew actually has been followed. The imposition of a curfew in the circumstances of youth offenders is not novel. In fact, it's clear from the bail decisions which are published that we have been able to review that the majority of bail decisions for young offenders carry either home detention or a curfew. The addition of electronic monitoring is essentially a practical thing to make sure that that curfew is enforced. We have significant experience of electronic monitoring of offenders on parole. We're confident that it works and it has an impact on community safety. This is beneficial, I think, for 2 reasons. It's beneficial if there are fewer youth who are committing crime while they're on bail. It's beneficial for the community. It's also beneficial for the young offenders, because a revolving door of bail courts and engagement with the law is not beneficial for young persons either. So, and it is important to note that we are not talking about young offenders who've pinched a packet of chewing gum at the checkout at Coles. 22C only relates to repeat offenders for serious crimes, either break and enter offences or stolen motor vehicle offences. And so that is the context in which we are proposing both the curfew and the electronic monitoring. There has been significant community discussion about young offenders who repeatedly come before the bail courts, and in fact this is one of the issues that we are trying to address with the new item 2. Bail granted under section 22C will be revoked in one of 3 circumstances. The obvious circumstance of failure to comply with bail conditions, nothing novel about that. Committing another crime, again, nothing novel about that. Or if they have interfered with the electronic monitoring device. We've now had the opportunity to see how the courts are interpreting section 22C. We see that there is resistance by the judiciary to the application of this section, and I draw members' attention to those cases that I discussed earlier. Having regard to the way in which section 22C has been operating, the amendments strengthen the intent behind this section and hopefully provide a greater deterrent with regard to this cohort of young offenders who are repeat, serious young offenders. So I draw these to the attention of the House. With respect to the second amendment that I'm moving, and I reiterate that we're discussing these together on the advice of the clerks, but we will be voting on these separately. So if you have any concerns about the first but are attracted by the second, they don't sit together. This second amendment, I think, is very important. Essentially what we are doing is saying that, yes, we agree that this is an extraordinary measure, therefore it should be a sunset measure, but it should sunset on the 1st of October 2026. When 22C was originally introduced, it was introduced for a 12-month period. And it was said that that 12-month period would allow an evaluation. The present bill seeks a 3-year extension of this period. And I take notice of what the Minister said about the DCJ monitoring group and the range of stakeholders that are involved. It is good to know that this is being monitored, but sadly the fruits of that monitoring have not been brought to this House, have not been made available to members of of this parliament, as far as I'm aware, have not been put in the public domain so that we can test whether this is actually working. And so the point of bringing that sunset clause forward is to say, look, 2.5 years should be a long enough period for us to evaluate this and to determine if it is working. I'm also conscious of the remarks of the Minister in relation to the nature of the wraparound services that are being made available. It is our observation that the initial rollout of these wraparound services in Moree has been very slow. Our understanding was that Moree was essentially to be a pilot, which is why it was a Moree response. And then we could see, is this total package, is this total approach working? And then look at what could be applied in other places where youth crime was particularly troubling. That simply hasn't happened. And so to provide a significant extension, a tripling of the initial period, and to say, trust us, we're the government, we will be rolling out these wraparound services, we will be telling you how it's working, we will be looking at other places. On this side of the House, we're a bit cynical, and we would like to see a shorter time period so that we can have an evaluation and, frankly, so that the government has that shorter time period right in front of their faces all the time, and they know that that actually is the deadline for the wraparound services. We don't want to push it off into the never never. We want the total responses now. And in terms of the rollout of services, I mention again the bail accommodation in Moree. It is encouraging to know that 3 groups have been identified, as far as the Minister's telling us today, who will run that accommodation. As far as I'm aware, we still don't know where that accommodation is. And we had one answer at estimates that a tender was about to be open for that. And we had another answer at estimates that there was a building about to be purchased for that. This is a huge degree of uncertainty at the end of what was meant to be a trial period. And I think there are very strong reasons for saying a 2.5-year period is long enough, and we are deliberately setting a timeline that says we want some accountability and we want to make sure that this isn't just about stronger bail conditions, it's also about appropriate services. And for those reasons, I would encourage people to support both of those amendments. Thank you.
Thank you. Minister?